to our review of the case law of the European Court of Justice. This is an event that we host twice a year, and it's my pleasure to be joined today by two colleagues. So unfortunately, Adrien de Hauteclocque, who usually participates in this event, has not been able to attend today, but we're extremely happy that at very short notice, Dorte Fouquet has been able to step in. Dorte is probably very familiar to many FSR alumni. She has worked with the FSR for many, many years. She has taught at our summer schools. She appears on our expert panels in many courses and is a true expert on European energy law and most especially in the field of environmental law. So Dorte, very much welcome to you today, and thank you so much for standing in for Adrien. And then my other colleague, Max Munchmeyer, who is completing his doctoral thesis at the European University Institute on the topic of energy solidarity, is now the up-and-coming expert on the subject. So we're very glad that he is with us today to talk about the case on energy solidarity. So we will start with Dorte presenting the recent judgment, Commission versus Germany. Dorte unfortunately cannot be with us for the entire event, and so she will outline the case and then she will take any questions if you have them. Thank you very much.
Thank you, Leigh. It's a pleasure that I can step in, and I'm sorry that Adrien isn't here because I normally like to listen to him. I have 10 minutes, I think. This is an interesting case, as all cases we present here are interesting, obviously, but this one is interesting because it goes to the essence of independence, of concretizing, unbundling of vertically integrated companies, so companies which are not fully separated in between distribution and production, to make it very brief. On the one hand, there the Commission was not in line with Germany's view that they have done everything to respect the directives on electricity and gas. And the other question, which is the question most discussed at the moment, at least in the German energy world, is the question of the independence of the transmission of the federal regulator, so the Bundesnetzagentur. Maybe we can continue because I use Adrien's preparation here. So there were several questions. As I said, it started with what do you have to do with a vertically integrated undertaking so that it is really operating with clarity in the European market. And there it is I find it personally very interesting, directly the first question, because there the Commission and the court followed the Commission is in essence of the opinion that there is concerning this integration and concerning our wish for vertically integrated undertakings, there is not a real territorial limitation. And one can boil it down. Adrien has put out here the conflict of interest, and the Commission does not. The Germans said, hey, you cannot go beyond with legislation concerning the European Union. You cannot go beyond the borders of the Union, so to say. But for the effective use of our own law within the Union, the Commission and the Court is of the opinion that we can have as an effective execution of our European legislation. We can look upon what is the player on the European market doing outside the territory. And so, for example, they made it very clear, and you can read it in 4.3. Also in alinea 4.3 of the judgment, as you can read, and I quote, furthermore, a vertically integrated company which produces or supplies natural gas or electricity outside the European Union may have a conflict of interest, I unquote, if it's not respecting the same unbundling profile outside the union, to make it very, very short. We can continue. The second question is on staff and management of the TSO. Do they have still some interest in other pies, and shouldn't we there have more clarity? This question is not, as I see it, it's not really discussed in the German energy world with vigor now after that judgment. But I would like to continue, and the same, next slide please, the same independence of staff and management, no other interest I have just referred to. So that is has to be proportional. But what is really making heads spin in Germany, and I can say on all levels, apparently including Bundesnetzagentur, the federal agency, is the very clear standing of the viewpoint of the European Court, together with the European Commission, or accepting or underlining the good procedure of the European Commission against Germany, is on the exclusive competence of the national regulator, as it is laid down in our directives. And you see here the most important articles are mentioned here, and especially the national regulator shall be responsible for fixing or approving sufficiently in advance of the entry into force at least the methodology used for setting the transportation and distribute tariffs, including the balancing conditions. And that should be independently of any public entity or political body. And only general guidelines could be possible, but not related to the powers and duties for this regulator. We can already go to the next slide, but I want to, so that is about the complete independence as the Commission and as the Court read it in the provisions on of our directives. And that's where the heat is on in Germany, because the wording, they say that we have to, or if this is so broad or so broad and wide, the discretion of the regulator, there seems to be a disadvantage for the political powers, especially the parliament, but also the government. And the question also, can the government issue further delegated ordinances under our Energiewirtschaftsgesetz, under the energy economy law, is very questionable. So guidance is very weak in comparison what the legislator is doing until now. So when I would analyze, or when I would conclude what the German government and the next German government will do, they will probably use the gas package, which is now on the table, so to say, the reform package under the Fit for 55 package, to clarify the roles of the regulator versus the roles of the legislator. I think when it comes especially to tariff setting, and we have already a lot of conflicts for distribution system operators who, when they do enforcement or renovation or bringing their system in line with the new energy world, that they have to invest. And then there's the question of interest rate. How much can they ask in the whole capex and opex mechanism? And it's the regulator already who is bringing down by sometimes 2 points the interest rates. And for the distribution system operators say, wait a minute, if we are curtailed that much by a regulator, how can we execute the political program and the legislative program of Germany in this energy system change? So in the end, there was some questioning if the if somebody should go to the Constitutional Court, the Parliament, that the so lange decisions may be used or so, but no, everybody with sense says we have to review the directive and find a better balance maybe, because the legislator's role, also my view, should be curtailed too much. That's what I wanted to say. Also, for the note, this case is against Germany, but in the past, when the infringement procedure started, the Commission had also looked into application enforcement of other member states. And the funny thing is that they were opening infringement against Spain. And then Spain acted and gave a press declaration when they had changed their system and said, we are now in order, we have the German system. So I wonder if now maybe the Commission will use this judgment to reopen views on other member states. With that, I think I should stop, no?
Thank you very much, Dorte. You stuck to the 10 minutes perfectly. Could you move your microphone a little bit? There was a bit of echo. If it was, I think it was a bit too close. Sorry.
Okay. No, it's okay. Sorry.
No. There was a bit.
Should I repeat all?
It was part. No, it was easy to follow. It was just a little bit of buzzing on the back.
Sorry. Yeah, I don't like this mic, but without mic, it's sometimes worse.
Yes, it's always difficult on with these online.
I apologize.
No.
To the listener.
But so maybe we have some questions from the audience before you disappear. We have a very busy schedule.
Only from the screen, I hope.
Yeah. Well, maybe if I could ask one question. We've seen the leaked gas package. I'm not quite sure what will happen before the 14th of December, whether there will be major amendments to the version that seems to have been very widely leaked, in fact, but a lot of it's copy-paste so far. So could we expect, do you think, a coalition of member states? I mean, we'll have France in the hot seat in the first 6 months of next year. I can't imagine that it is a country that wants to give a huge amount of discretionary power to agencies either. So do you think that there would be a coalition of governments that might well push for a more limited sort of set of powers?
Yeah, I think at least you will find a coalition of those who want more clarity, also on some boundaries and some privileges, and it might be a very bizarre coalition. So I can, for example, in the case Sweden intervened on the side of Germany, I think, and so there will be some member states who have a balanced system, who have these. It's not the only independent authority they have, but with a specific etiquette under the directive, they might compare which is the setting of other independent agencies and regulators in their country and in the union. I only hope it's not an unholy alliance coming up with people who have hardly nothing and are always in care, almost not caring. But we will see. But I think, yes, there are some member states. And okay, France must be a bit the negotiator while it's under presidency. But France view in energy, we know France is, very public service.
Okay, thank you. I don't know if there are other questions coming through. I don't see anything yet in the chat, so that means it must have all been very clear, but a very important case indeed. There's also commentary on what it means for the famous Moroni ruling. Some people think this case can be interpreted as giving more independence to agencies generally. So this could be important for Acer, for example, in the future. That's another element of this case that I think we see quite a bit of discussion around. So it's an important case, an important precedent. And we've been very privileged to have you here to talk about it and to tell us the reaction in Germany as well from your own experience. So thank you very much indeed. And
pleasure.
We hope to see you online soon. Don't
Yeah,
disappear completely. Thank
we
you.
don't.
Bye.
I hope not.
Bye.
Tschüss, Leigh. Thank you so
Bye.
much.
Bye.
Bye to everybody.
Okay, so we will move on to the next issue. If we can have the next slide. And this is actually moving on to the presentation by Max Munchmeyer, who, as I mentioned, is writing his thesis on the topic of energy solidarity and has been presenting on this case in a number of fora. So he is very able and thankfully willing to talk about it. So Max, I will keep time for you, and you have 10 minutes. Thank you.
Wonderful. Thank you so much. And thanks very much to you for giving me the opportunity to present today the findings of the Court of Justice's ruling from the 15th of July in the case of Germany versus Poland, a case, as many of you will know, in which the General Court confirmed that, the Court of Justice confirmed the General Court ruling that had held that energy solidarity, in fact, is a justicial principle of EU primary law. And I think it's quite useful to go back to that primary law basis, first of all, and to look at what the Treaty of Lisbon says, because it's introduced for the first time, as you will be aware, an energy competence in its Article 194. I apologize for all the text on the slides. I think it's interesting to see the article in its entirety, but I've highlighted two particularly important passages here, and I'll draw your attention first to the one that I've highlighted here in paragraph 2 of the Article 194, saying that measures adopted in pursuit of the European Union's energy policy shall not affect a member state's right to determine the conditions for exploiting its energy resources, its choice between different energy sources, and the general structure of its energy supply. So in fact, enshrining a sort of energy sovereignty within the very primary law of the Union. And that's been I suppose, quite a clear provision that the Union may not constrain national energy choices too much, insofar as to prescribe which energy sources may not be used, for example. What had been less clear is this provision that I've highlighted in paragraph 1, is that Union policy shall pursue the set of 4 policy goals enumerated in points A to D here, in a spirit of solidarity between member states. And there's been in the academic literature and also in policymaking circles, always a sort of understanding that this is sort of maybe at most a guiding principle for the legislator, rather than a binding provision that can be enforced as such. However, that changed when a case was brought before the General Court by Poland, pursuant to an exemption decision that had been made in relation to the Opal natural gas pipeline that you see in this map extract here, which in essence transports gas that arrives from the Nord Stream pipeline through along the eastern border of Germany all the way down to the Czech Republic. After the Commission had approved a decision by the Bundesnetzagentur, the German regulator, to modify a third-party access exemption that had been granted to the pipeline in 2009, to modify it in a way that would allow, in fact, Gazprom to use the entirety of, or up to the entirety of the Opal natural gas pipeline, as opposed to the 50% it had been allowed to use previously. In response to this, Poland brought a case before the General Court, claiming, amongst other things, that the European Commission, by approving this amendment to this exemption, had breached its duty on the European Union primary law, and more specifically, that the exemption granting procedure under the Natural Gas Directive must be read in conjunction with that Article 194.1 TFEU, and that the solidarity requirements, that the spirit of solidarity in that provision imposed an obligation on the European Commission to conduct an assessment of how this proposed exemption would affect not just the interest in Germany, but how it would affect European Union energy security as a whole and the energy security of other member states, notably Poland and the Czech Republic. And in quite a surprising ruling, the General Court had said in September 2019, yes, the principle of solidarity is a binding principle of Union primary law, and it laid out the content of that principle in quite sweeping terms. So as you can see in the passage that I've highlighted here in paragraph 17, it says that the content is such that the European Union is bound by an obligation of solidarity towards the member states. But, and on the other hand, the member states are bound by an obligation of solidarity between themselves and with regard to the common interests of the European Union and the policies pursued by it. So that in turn, according to the General Court, required member states to avoid adopting measures liable to affect the interests of the European Union and the other member states as regards of the security of supply, its economic and political viability, the diversification of supply or sources of supply, and to do so in order to take account of the interdependence of member states and their de facto solidarity. So laying that obligation out quite broadly, stating, however, elsewhere that this does not mean that one member state's decision must never negatively impact another member state's energy interests, but that there must be a balancing exercise between interests, and that in this event, because the Commission had not conducted such an assessment, it had breached its EU primary law obligations, and that thus the amendments to the third-party access exemption granted to the Opal pipeline must be annulled. This then was appealed by Germany, but the Court of Justice in July of this year followed the opinion of its Advocate General, who had recommended that the court dismiss all grounds of appeal, which essentially had oriented themselves along that established wisdom on energy solidarity as merely a political provision, as a concept that was so abstract that it could not possibly be construed to constitute a primary law, a justiciable primary law obligation, a basis for judicial review. But however, the Court of Justice says no, it is such a binding provision, and endorsed the quite broad version of energy solidarity that was put forward by the General Court, as solidarity applying not just between member states, but also in this sort of more vertical dimension between the member states and the European Union. And it specifically rejected the notion of solidarity as something, as an emergency mechanism that had also been claimed by the applicant, saying that it cannot just be a contingency mechanism, in essence duplicating those sort of emergency assistance provisions in the Treaty on the Functioning of the European Union, such as Article 122, 222. No, solidarity is broader and requires this sort of balancing exercise. And quite importantly, I think the Court of Justice also rejects the exclusive link between solidarity and energy security. And I think this is quite crucial, because solidarity is usually, certainly in the scholarship, talked about almost always in connection with energy security. And in fact, if you look at the history of the drafting of the Lisbon Treaty, was inserted, that notion of solidarity was inserted into the treaty on the behest of member states that were concerned about energy security issues. Of course, a concern that was on everybody's minds due to the gas supply shortages that were experienced during the very drafting of that treaty. But here the Court of Justice said, no, it cannot just apply in energy security, but it must also apply in all of the other energy priorities that are enumerated in Article 194.1. So that extends to energy efficiency, renewable energy, the functioning of the internal energy market, and interconnection as well. In fact, the court states in paragraph 43 of its judgment that the principle must apply to all these provisions, and as is apparent from the wording and structure of the provision, it forms the basis of all of the objectives of European Union's energy policy, serving as the thread, quite an interesting phrasing I thought, the thread that brings them together and gives these policies coherence. So if we look at the future relevance of the principle, if we look at how it's been applied so far, you can already, after the General Court's decision in 2019, the European Commission has already started to apply the solidarity principle in its exemption decisions on major energy import infrastructure, both in electricity and gas. I've just listed a few of the recent decisions where the Commission now makes explicit reference to energy solidarity and treats this as a sort of a procedural requirement. The expressions so far are rather formulaic. It says there has been a stakeholder consultation has been opened in which other member states have also been able to participate and voice any concerns that they may have regarding energy solidarity, regarding their interests. But what I suppose I'm looking at in my research at the moment is that the quite broad scope of the solidarity obligation that was put forward by the Court of Justice, I think opens the door to a much more muscular, a much more substantive solidarity principle in theory, which I think it'll probably require more solidarity litigation before the Court of Justice to find out, first of all, how far these obligations go and how they manifest themselves in other dimensions of in the other policy priorities of European energy policy enumerated in Article 194, paragraph 1. I think, for example, particularly prescient is the question of how it works in decarbonization. Is there now a solidarity obligation by member states with, say, the 55% decarbonization target by 2030? Is there a way to go through the court to, in essence, enforce that of solidarity between member states? Or in fact, on the other hand, can solidarity act as a mechanism for member states that might be more reluctant to follow the quite ambitious decarbonization agenda set by the European Commission to resist increasing, say, decarbonization or energy efficiency targets, or in fact to bolster claims to receive more monies from those transition fund mechanisms that have been approved by the European Union or proposed, in fact. Such as is the case in this for the Social Climate Fund to sort of ease the socioeconomic blow of the energy transition. But I see that I'm out of time, and I'll stop here, and thank you again for the opportunity to present today.
Thank you very much indeed, Max. And thank you for opening the Pandora's box that this case, in fact, I think.
Sorry, I'm unable to hear you. I'm not sure if anyone,
Okay.
I don't know if it's just me, but.
Yes, we hear you.
Yeah, I think it says I'm okay. Can you hear me now, Max?
For us, you're okay.
Okay. Yes. Yeah, and I can hear I see on the chat the participants can hear me. Can you fix it, Max? Okay. Thank you very much. Can we have the next slide? Thank you. So thank you very much indeed, Max. We'll come back, I'm sure, to this case, which will resonate through, as you mentioned, many of the actions now being undertaken in the context of the Fit for 55 exercise and the whole push to decarbonisation. So I would like to turn to another area of the case law where the courts have been extremely active, and that's in the area of state aid. And of course, the energy sector has always been a sort of super spreader of state aid cases through the years, and that level of activity never seems to really dry up. There are three sets of cases that I want to have a quick look through today with you. The first one is a procedural one, when the Commission has to open what we call a formal investigation. That's a very important step because it's the step that allows so-called interested parties, third parties, to express their views on the compatibility of a proposed aid measure. The second element is also procedural. There's been some recent case law as to who has standing to bring a case before the European courts. And finally, the old chestnut, I'm afraid, that always comes back is what actually do we mean by state aid? And it's still the case that after more than 50 years of jurisprudence in this area, this is still very much a disputed concept. So those are the three things that I'm going to look at. I have a little bit more time because I have more cases, but Max will keep an eye on me and stop me from going over time. So the next slide, please, Max. Thank you. Okay, so the first case I'd like to talk about is a case called Tempest Energy. This came from the UK at the time when the UK was still a member state. And it's a very interesting case for many reasons. It was the first case that the court has had the opportunity to look at in the area of capacity remuneration mechanisms. And I hope you all know what they are, but these are the mechanisms that many member states use to fund, as it were, investment in energy when they are concerned that there is an issue of reliability of supply in their energy market, particularly the electricity market. So to fund these mechanisms, obviously you need the state to step in one way or the other. And virtually all member states have set these schemes up, and the Commission has subsequently approved most of these schemes. Now, these schemes are contentious in many respects, not least because in most member states, as confirmed by a recent Commission assessment of its own guidelines, in fact, these mechanisms are primarily used to the benefit of existing fossil fuel producers. And Tempus concerns demand side response. So this is a way, instead of adjusting the supply side, it's to adjust. Tempus's business model is based on adjustment to the demand side to improve flexibility of demand, also known as demand side response. And Tempus was at odds with the UK's first decision to introduce the capacity market mechanism in that country, and challenged the European Commission's green light given to the UK mechanism after a 1 month investigation, a 1 month preliminary investigation, without opening this formal procedure. So theoretically, in terms of European state aid law, Tempus did not have the opportunity to give any formal input into this process, because that possibility arises only if this formal investigation is opened. What the Commission had done, however, was it had conducted a very lengthy pre-notification procedure with the UK government, lasting well over a year, so that the idea being that the UK government could meet any concerns of the Commission, adjust its scheme, and then it could all be quickly approved, which was exactly what happened. Now, Tempest said, well, wait a minute, we actually knew that the Commission was busy with this pre-notification, and we and many other demand-side response providers, as well as other electricity generators, actually submitted correspondence and comments to the Commission to draw the Commission's attention to the shortcomings of the British scheme, and that it was actually contrary to the then very new guidelines that the Commission had just issued. So the combination of the length of the proceeding, the novelty of the issue, and the amount of aid at issue were all, and the critical observations that had been submitted, even at pre-notification, were sufficient to allow the General Court to reach the conclusion that the Commission had failed in its obligations as a diligent administrator, and it should have opened this formal investigation. Now, both the the Advocate General, and then the court itself, the Court of Justice, were not in agreement with their lower court, and they overturned then the General Court's ruling. And this is quite a victory for the Commission, in fact, because it gives the Commission much more discretion as to how it conducts its procedures. And what's very important is that although the General Court had said, well, the Commission should have taken a more proactive role and gone and looked at whether or not the evidence that it was being given by the member state and all the documentation was sufficient, the Commission should have actually, because third parties had presented concerns, the Commission should have gone and actively looked a bit further than what the member state was telling it. And the court found that that was actually not required. So there is also a substantive element here, because one of the arguments that had been upheld before the General Court was that the Commission had also been wrong on the merits of the compatibility test, in particular the application of the test of technological neutrality as regards demand-side response. And that too then was quashed by the Court of Justice. So if I could have the next slide, please. However, although the Commission seems to have scored a victory here, and it seems to be allowed to continue to conduct in the first phases of a state aid negotiation, more or less a bilateral discussion with the member state to the exclusion of everybody else, the court did in its ruling emphasize that the Commission must conduct a diligent and impartial examination of the contested measure, so that it has at its disposal, when adopting the final decision, to establish whether there is aid or whether it's unlawful, the most complete and reliable information possible for that purpose. So the Commission should satisfy itself that it's got all the necessary information before it. And that could well mean, and as we'll see in some later case law, the Commission still should be not entirely passive and not entirely dependent on what the member state provides in a state aid procedure. So if you could have the next slide, please. However, and in a case that was pending at the time this litigation in the UK was proceeding, Tempus Germany and Tempus Sweden brought another case, again contesting the fact that the Commission had closed the procedures and found a capacity mechanism in Poland to be compatible with the guidelines and with the treaty. And again, Tempus Poland, let's call it Tempus Poland for that's easier. They claimed, well, the Commission obviously must have had serious difficulties here because, again, there was a very lengthy pre-notification and then a fairly short preliminary investigation, and then a decision declaring the aid to be compatible. Now, this is an interesting case because, of course, the General Court had to apply the ruling of the European Court of Justice, annulling its previous ruling in Tempus, UK. So unsurprisingly, then, the General Court found that the length of the procedures, again, is 18 months in pre-notification, 11 months in pre-notification, that this was not sufficient in itself to give rise to serious doubts about the compatibility of the aid, nor was the fact that there were very large sums of money involved problematic, nor indeed the fact that this benefited primarily fossil fuel producers, again, contrary to the spirit, if not the strict wording, of the state aid guidelines at the time. What's also interesting, actually, is the whole discussion about the role and purpose of this so-called pre-notification procedure. Now, this is something that the Commission introduced several years ago to speed up state aid decision-making. And we have a code of best practices, which determines how the Commission and the member states should conduct themselves during this pre-notification. But one has to stress here that this is completely confidential, and there's no obligation on the member state to inform third parties that they're engaged in this. There is a possibility that they can involve the beneficiary, but that's up to them. So this is a process that takes place really in, you could say, in secret, because there's no obligation to notify anyone. And yet, interestingly, the General Court in the Polish case said, well, you know, a diligent operator like Tempus should have actually found out itself and submitted observations, even although it had no formal rights to do so, and even although it had no possibility of knowing that this pre-notification period had started. Also, the General Court, having said in the first Tempest case that the pre-notification period served a specific purpose, and that was to make sure that the Commission had all the information it needed so that it could move on quickly to the so-called preliminary investigation that's provided for by the treaty. It now says in this Polish case that actually it's possible for the Commission in the pre-notification phase to conduct a compatibility assessment. So it can look at the measure and decide whether or not it might be problematic and ask the member state to adjust it. And that's what happened in the Polish case. Poland had notified a draft law in this pre-notification procedure, and the Commission came with suggestions as to how the law could be amended to eventually ensure its compatibility. So this case is quite a big step back from the General Court's ruling in the first Tempest case, and seems to be even more far-reaching than the Court of Justice's approach following the first Tempest case. And if we could have the next slide, please, Max. And this seems to be also confirmed by another judgment handed down just 2 days afterwards in the long-running Lithuanian LNG saga in the Achema case. And we've discussed these cases before in this session. They do tend to go on and on, these cases, but this one is quite an interesting one, because here we're concerned with a decision modifying an earlier aid decision, which had been approved. And the Lithuanian government amended the scheme, submitted it to the Commission, and the Commission approved it. And the new scheme, which the Commission approved, concerned then the introduction of a levy to finance the so-called designated supplier, Litgas, who is entrusted with a service of an SIEG, so a public service obligation, service of general economic interest. And the levy then to finance the services provided by Litgas was placed on end users of gas. Now the Commission approved that change to the system and the introduction of this levy without, again, opening what we call the formal investigation. So it gave a green light. Now, Achema this is a fertilizer company, so a large gas user who's obviously affected by this, challenged that decision and was successful And here it's interesting because many of the same arguments were used as in the Tempus case: the length of the pre-notification contacts, the number of them, that continued over quite an extensive period, indicating complexity. But what was important here was that when the court looked at the nature of the compensation for the service of general economic interest that had been entrusted to Litgas, it found that the Commission's assessment was either incoherent or incomplete, largely because the Commission failed to check why, in fact, Litgas was being compensated for many costs that weren't necessarily part of its public service obligation, including balancing costs and so-called fuel boil-off costs. So it's interesting that we have these different parallel lines in the case law. But I think, and if we can go to the next slide, please, Max, just to summarize, in this, it's very important because if somebody wants to challenge the decision not to open the formal investigation, then they have quite an uphill struggle. So it's important to realize that you have to be able to, you as the challenger have the burden of proof to show that the Commission has these serious difficulties. And the length of the procedures then is not in itself indicative of serious difficulties. It has to be reinforced by other factors. And this is perhaps standard case law, as I've illustrated here. But the Achema case gives perhaps a glimmer of hope for those wanting to challenge these decisions if you can show the assessment is incomplete. One problem, of course, here is you have to know what the Commission has been given by the member state. And because this stage of the proceeding is theoretically a black box to third parties, then it's really depending on what is in the public domain at national level already, if you have access to this kind of information. I'll come back to that later. So moving on now to the next slide. And this one concerns the next subject, which is standing. Who can bring a case? Now, this is, again, very important because we see state aid litigation is really quite a battleground at the moment in the energy transition. And obviously, as resources become scarcer in all senses of the word, you will see different parties fighting over them, hopefully only in court. And this is what was at issue in this case called CAPA, which was decided in September by the General Court. This concerned, again, a Commission decision approving a French aid measure to support offshore wind. And the Commission didn't open the full inquiry. It gave the green light at the end of the preliminary investigation. It was challenged, that decision was challenged here, not by a straightforward competitor to an offshore wind producer, but by a fisherman cooperative. And they argued that the presence of these large wind turbines would disturb their fishing rights, as it were. And the question here was, well, does a fisherman's cooperative have standing to bring a challenge to a decision by the French government to license a particular part of its offshore territory for the establishment of wind turbines? The Commission said no, and the General Court upheld the Commission's reasoning that even if there's indirect competition between the fishermen and the offshore wind producers, it's a question of access, indirect competition to a raw material. But here, the raw materials are not the same, according to the court. One was concerned about fishing, the other wind. So there was no competition on the maritime space as such. So these two different interests were not competing to use the maritime space. The court seemed to think that this was these could coexist, and it was underlined that decisions on access to that maritime space were national public policy decisions. So this is an important case, which shows that you would have to actually show, you could show if there was competition for the resources that you could have standing, but you have to show that if there's a negative impact on you and the resources you use, it must flow directly from the aid to the other party itself. And that was not the case here. The General Court ruled that the negative externalities here came from the national decision to locate the wind projects, the wind farms in that maritime space. So that is perhaps a case that will, it's not been appealed as far as I know, but I think we'll see more of those kind of cases coming before the court competition around natural resources. So if we could move on to the next case, please. Just to mention, there are many of these cases about whether or not the Commission should have opened a formal investigation or not. We have a case concerning the coal adaptation support scheme in Spain, where the Commission did open the full procedure, and the beneficiaries have objected to that. They claim there is no aid, so there was no reason for the Commission to get into the intricacies of this procedure. Their appeal at General Court level has been rejected, and that case is now on appeal to the General Court. What was at stake here was an argument as to whether or not the measure was selective, and the coal providers have claimed that it's not, and therefore no aid. Then the other case that's also been rejected at General Court level, but now also on appeal, is a case brought by the Irish Wind Farmers Association, who have argued that the amount of tax paid by fossil fuel producers allows them various selective advantages. The Commission found that that wasn't the case. There is a difference in the amount of aid paid, but that's due to what we call the nature and logic of the tax system in Ireland. It's not a selective benefit. Again, that was a case that was disposed of without a formal procedure, and that's also now on appeal to the full court. So those are important procedural cases. And then moving on finally to the last issue in the state aid case area. And this is a case concerning German network charges. This is, in fact, a case with a very long history. And I believe this will also be appealed to the Court of Justice, although that hasn't been formally registered yet. But this is an important case for those of you who are familiar with the German law on support for renewable energy. You might remember there was a very important ruling by the Court of Justice in 2019, where it was held that the German system of financing renewables was not actually a state aid. That was quite a surprise ruling, because the Advocate General, the General Court, the Commission, and most commentators had just assumed it was a state aid. But what was very important in that so-called EEG case was that the court found that there was actually no compulsory levy charged on the users of the German networks. There was just a price differential that was collected by the TSOs, but the TSOs are private parties. And the TSOs then had some discretion as to how they applied this fund that they had collected. Now that case then is relied upon now, of course, by many member states and not usually with success. And in fact, the German government understandably relied on the same tests in challenging the Commission's decision that exemptions from network charges for large users, which was financed also by a user's fee paid by the final customers, was an exemption and therefore a selective advantage and therefore aid paid for by or through state resources, paid through the levy charged on final customers. In this case, the General Court said, yes, there was indeed a compulsory levy. It had the form, at least, of a charge, but the effect of a levy. It was compulsory. And the state controlled the way the funds that were collected by the private TSOs as well. So therefore, it was a state aid because these were state resources. The compulsory levy element plus the fact that the German authorities controlled the use of the levy was sufficient to make it a state aid. Now, it's not perhaps very clear from that ruling how they distinguish this famous EEG case, and that's probably why it's subject to challenge or will be subject to challenge. And then another case where similar issues have been debated is a Czech case, FV and Hotve, I hope I pronounced it correctly, where similar issues as to a levy that all end users had to pay for providing support to solar producers, whether or not that was a levy or not. And here the court says it's not necessary for the levy in question to be designated as such in Czech law. It's really the effect of the measure that's very important. So because the measure falls within what can be described as a fiscal levy, then that is sufficient for the purposes of Article 107, paragraph 1, to define this as state resources. So the state aid rules apply. So these cases are complex. We see many, many cases on this very fundamental question coming to the courts, and it's sometimes very difficult to distinguish as to why some are put in the state aid box and some are not. It can be really a very complex factual question in the end. So could I have the next slide, please? So that takes me through the state aid cases, which, as I say, are a very important source of conflict in the energy area. And if we turn now quickly to the list of pending cases, we see that same pattern being repeated. So we have a lot of competition cases, though, coming up. And that will be interesting because although we had lots of competition cases in the energy space in the 1980s and 1990s, we haven't had such important cases. We haven't had a sort of an equivalent of Google shopping in the energy sector. But we have some very important cases coming up. We have a case brought against the Commission's settlement with Gazprom, on antitrust case. We also have another case concerning the asset swap between the German E.ON and RWE. We have a case involving compatibility of aid measures to a nuclear power station, PAX, in Hungary. We have another case on whether or not the Commission should have opened the formal investigation into a capacity remuneration mechanism in Italy. That's Tirreno Power. And then we have a case concerning solar support to solar electric. We have SunWest, similar case. So these are all the French solar support schemes. Coming closer to my home here in the Netherlands, there's an important case where the Dutch government has provided aid to producers of or owners of coal generation plant that have been closed down because that's no longer complies with the energy targets here. They have received some compensation, so that is also being contested. And then we have cases concerning the validity of state aid guidelines and also on the ETS scheme post-2021. So these are all important cases. And again, the even more recent ones that have just been registered in the last 4 weeks. We have two competition cases, Bulgaria Energy versus the Commission on the application of Article 102, so abuse of a dominant position on the part of Bulgarian Energy. We have a reference coming from the Italian Council of State concerning the application of Article 102 to the electricity company Enel. And then on not directly state aid, but a case concerning standing and emission standards in the motor vehicle sector is a City of Paris. This is an important case on the question of who has an interest to bring a case against the European authorities, in fact. And then finally, we have yet another case on the definition of state resources in concerning a levy to finance combined heat and power. So a similar case in Germany as to the cases we discussed earlier, where often this type of support is funded by a levy on final users. So interesting pending cases there. And moving on, we have lots of cases against Acer. So we have quite an important case before the full court. This is the higher court, where Acer is appealing the general court ruling in the Achema case. Now, the general court quashed Acer's decision denying an exemption to Achema, which is a cable between the UK and France. And that is proving rather complex because the general court held that Acer and its Board of Appeal should have conducted a full review of the Acer decision. So that puts quite a heavy onus on the Board of Appeal to go into all the facts as well as the legal arguments, as opposed to just conducting a marginal review, which is what it assumed it could do. So that's an important aspect in this appeal. And there's also then a parallel case going on here because following the first ruling in Achema, the UK withdrew from the EU. So one of the interesting questions is whether or not the Board of Appeal and eventually Acer is bound to take a new decision. So this is a very interesting area. And we have several cases concerning the competence of Acer that we've had recent hearings on. So Magyar, the Hungarian case in the gas sector, we have a very important case brought by the German regulator against Acer's decision on the core, so-called core electricity market area. And there are actually 10 other appeals pending against Acer decisions. So this is booming area. And the next slide, I think, takes us to my final slide. And I just wanted to point out there's some very interesting institutional cases where we're not looking at competition law or state aid law for a change, but we're looking at the type of issues that both Max and Dorte were talking about. So how we interpret the treaty articles in general, or how do we interpret directives, so we call them institutional cases. So we have a very important case concerning a lignite mine in Poland, with challenges being brought by the Czech Republic. And if I'm correct, that also raises some energy solidarity arguments as to whether or not a lignite mine so close to a border should be commissioned without taking into account the interests of the member state joining it. And then we have Nord Stream 2, a case which involves an appeal against a ruling from the general court, and this concerns them whether or not a single party can challenge a directive. The general court said no. Directives are general measures, and you have to show both individual and direct concern to challenge a directive. That's a very high barrier to jump across. But very interestingly, the Advocate General Bobek, in his opinion in early October, has said the General Court has got it wrong, and he has recommended that, in fact, the court should recognize that Nord Stream 2 has standing to challenge a directive, and that directive was, of course, adopted actually to meet the fact that Nord Stream 2 as an interconnector was not covered by the original gas directive of 2009. So that gas directive was amended in 2019, and it really only focuses on Nord Stream 2. Then there are two other cases worthy of note. The right to be connected to a transport or distribution grid. In the case of Latras gas, this is an issue that comes up quite often. And you'll see that the Advocate General confirms existing case law here and said there is no obligation, but it's an important case, of course. And then finally, whether or not national legislation can guarantee network access for renewable energies as a form of service of general economic interest. And here again, we have an opinion already from the Advocate General who says yes, as long as the conditions imposed then by the directives are respected. So there's some very important cases here on the scope of the gas and electricity directives then that are in the works, so to speak. So it's I kind of watch this space, but there are quite a lot of spaces to watch, and we'll come back, of course, to these rulings to discuss them with you in later events. So I'm sorry if I ran on a little bit, but there was quite a lot of material to talk through, and I hope that you might have some questions that I can hopefully also answer.
I think there'll probably be quite a lot of questions for you, Leigh, given the amount of ground you've covered. I just saw in the chat there's one question on solidarity. I might just answer that while the rest come in, if that works for you.
Yes, on you go.
Because one participant asked, what are the tips and tricks for national and EU governmental bodies? For which measures do they need to consider or motivate the energy solidarity principle in their decision making? Is this for any kind of local, national, or EU energy measure? And I suppose just to note, the addressees of the obligations of the obligation of solidarity as defined by the Court of Justice in its ruling are the member states and the European Union. And then I suppose the actions that need to be, that are sort of nominally subject to solidarity is really anything with a transboundary impact, which makes it so difficult in a system as connected as the internal market in energy to sort of determine the right way of balancing energy interests, and that is why I think the interpretation that's been given by the Court of Justice is so broad that really it's going to require perhaps some creative interpretation and future litigation to see how what exactly the scope is in terms of what one could particularly imagine in terms of decarbonization, that there might be some mobilization in that regard with member state solidarity towards EU targets. And I think particularly a litmus test for this might be in 2023, when the procedure of updating national energy and climate plans starts, which is really, I suppose, pan-European, the achievement of pan-European targets through this bottom-up procedure could be said to be an exercise in solidarity. And I think it'd be interesting to see whether that principle will play a role in those sort of in that process, and which side member states or Commission will mobilize it in that way. We just had a question coming in on compliment on the webinar and asking about the presentation materials being sent out to participants. I think we'll be able to make these available on our website, if I'm not mistaken, and also compose the highlights of this debate.
Yes, I think the event is recorded, if I'm right, and the presentation is available on the website, will be available on the website. Yeah, that's correct, indeed. I think I'm just thinking aloud, but of course the gas package has been leaked, but I'm not sure that the concept of solidarity has permeated its provisions as such. I don't recall seeing any references to it. I have to go back now. Now that I think about it, I'll have to go back and have a close look at it. But I don't know if you've had time.
I haven't had a chance. That would be interesting to see whether it's a formal sort of it's gone into legislation already. I suppose ruling being quite recent.
But I think one of the big questions is to whether it will go beyond a procedural sort of formality, and indeed, as you said, whether we'll see substantive rules emerging as to what it means. Yeah. Somebody has done.
I see.
Yeah.
47.
Okay. Right.
Take a note of that.
Yeah, very good. So it's worth investigating whether how the concept is about to be deployed and whether it will make a big difference.
Certainly, yeah. I think it's difficult to gauge the impact it's going to have. I think you in fact wrote in a commentary on the general court judgment that it's unlikely to be a silver bullet for European integration, but but it might lie somewhere in between and it's purely procedural and a very strong substantive, strong substantive obligation. Just see if we have. If anyone else had a question, now of course it's the time to submit these also via the Q&A function. I suppose we can take them. That is on the bottom bar of the screen.
think we might be reaching closing time on a Friday afternoon. Not least because here in the Netherlands, everything does close now at 5 o'clock. So we haven't got much time to run off to shops and do whatever. As we have a kind of 5 o'clock curfew almost. So I'd like to thank everybody for listening in today, and I hope it was useful. It's always a lot of information, and we have to cover quite a lot of lengthy cases as well in a short space of time. But I hope we've been able to highlight some of the cases that are very important in for the development and application of European energy law. And as I mentioned, the presentation will be available, and the slides and the recording will all be available via the website. And our next event from the FSR EU law area will be a seminar that we host together with the Energy Community Secretariat in Vienna. It's our Vienna Energy Forum, and we had originally hoped to have had a live event, but of course that proves to be impossible, as of course we have very tough measures now in place in Austria. But we will have an online seminar looking in fact at elements of the gas package, and that will be on the 16th of December. There should be a save the date going up on our website shortly, announcing the speakers and all the details of that. And that will be the final event from the law area for 2021. So hopefully in 2022, we'll all meet up again in person somewhere, and that we won't just have to Zoom and communicate online. So thanks to Max and Dorte for Dorte for jumping in for Adrien, and Max for providing again a very lucid account of this solidarity principle. And I'd like to thank the team in Florence for hosting the platform and making sure everything ran very smoothly as usual. So I think it just remains from us to wish you all a very good festive season under all the circumstances, and keep safe. Thank you. Okay, bye-bye.
Goodbye.